All right, check. Oh, all right, ladies and gentlemen, I'm going to call this meeting to order of the Public Safety and Homeland Security Committee. We have on our agenda 4 bills. I'm going to ask, still waiting on one of the authors to arrive. I'm going to call on Representative Bonner, if he would, to come present HB 534.
Thank you, Mr. Chairman. We're working off of the subcommittee substitute from yesterday, LC 392986-ECS. So what is different than what full committee has seen previously is we went in after working with the chairman and made some adjustments, in particular to line 46. We changed the period of suspension. It now says shall be up to 12 months rather than shall be 12 months. And then we adjusted the penalties to bring those more in line with the DUI penalties. So back in section 6, starting at line 318, we adjusted those punishments to be in line with current DUI statute. And one of the things that did, in addition to changing those dollar amounts and timeframes imprisonment, it did push back the ability to seize that vehicle to after the 3rd offense. And with that, Mr. Chairman, those are the only changes. I'll be available to answer any questions.
Okay, we got some comments. Number 15 over here. Who's that?
Oh, that's me. If you had others, I was just going to, we've heard it in committee before and had other testimony at the appropriate time.
Okay, thank you. Any other comments at this time? Number 6.
Thank you. Yes, I want to thank the gentleman for bringing this bill. And I wanted to discuss just a few small points let me move my mask. In showing this bill to law enforcement, one point that they brought up to me was on line 19 through 21. Perhaps it would be helpful to add in the term reckless stunt driving. That is the new activity that is being defined in this bill. I have talked with legislative counsel about that, and she felt like that these terms, when you do the organizing and promoting, that you aren't saying come out and recklessly stunt drive. You're saying come out and drag race and lay drag. So she felt like that was covered already. But I would say when law enforcement was reading, that was confusing to them that the new term wasn't put in there. So I don't know. So at some point, depending if anyone has any comment on that, we can see if we need to have an amendment. The other feedback was from law enforcement and from Solicitor Generals that this will be the biggest, most effective part of the new law is the cutting down, being able to charge people with the organizing and promoting with something. So another point that was made is that there is no graduated penalty for the organizers and promoters on line 21. So I had an amendment for that, and I gave it to Trey, the governor's attorney. I know you said yesterday when we talked, Chairman Bonner, you weren't sure you wanted to amend the bill today, but that is something that I would be supportive of. And so we can give it to the Senate, or if it's the will of this committee, we could talk about that. And I think, excuse me, Jenna, would you have those amendments handy, even if I didn't, or from what I had written up? Electronically, yeah. If the committee wanted to address those items. And the other point I will just say is that as a member of this committee, we've talked before about penalties and fines, and I know in other conversations we've had about I remember conversations about community service and, when I was a new legislator, learning about, well, when do judges do community service? So they always have the ability to do community service. And one feedback from a solicitor general I talked to was, you should require community service. That's people's time is more valuable than anything. And with DUIs, I know people, maybe you do too, who've paid their fine, walked away and haven't really changed their lives as much. And so that was another amendment, is to require community service for all of these offenses. So I have amendments for those if the will of the committee wants to discuss them, but if not, we'll move forward. But I just wanted the opportunity to talk with you, my colleagues, about that kind of feedback.
Well, thank you to Representative Evans for those conversations. Certainly valid points all. I would submit that this is, the bill is not perfect, and I think we do have an opportunity to perfect it, along the way, even outside of this committee. So I would appreciate that conversation. But it's certainly something we can work on, I think, once the bill gets out of committee.
Okay, Chairman Powell, you have a question, comment? Who's 15?
Oh, I'm
Donna?
sorry, that's me.
Who's 15?
That's me.
Okay,
Sorry.
go ahead.
Thank you. So I just wanted to point out that though I don't know that it would change the language really any to make the amendment, I'm not sure because it does state back in 310, any person who operates any vehicle while drag racing in violation of code section or laying drag is committing that offense of reckless stunt driving. And again, I don't know. I don't necessarily disagree that you could put it in there, but I'm just not sure that it needs to be in there since that statement's already
Well,
stated in the.
yes, it's the
in the
opinion of
code.
the chair. You probably really don't need that. I think it's covered pretty much in the language that's detailed. Number 14, who is that? Is that Chairman Clark?
Yes. All right. Thank you, Chairman. Line 344 of the bill, and I just want to state I support what we're getting after with this bill. I do have a concern. I know that the questions surrounding civil asset forfeiture has been brought before the body before, and line 344, arrested and charged with a violation is to be declared contraband and subject to forfeiture. I would like to see it say arrested and convicted, that they've been proven guilty before somebody's property is taken away.
One of the reasons for this bill was the fact, and if you don't mind, one of the things for the bill was, and I share some of your concerns, but I mean, if you've got somebody out there who is partaking in this activity and this is their third charge, I mean, the problem is these people that are doing this, they're repeat offenders. So if you take out the vehicle that they're using to do that, not only, I mean, you're making it safer on the streets if you take the vehicle away. They're not being released from custody and then going right back to the car to do it. So, the opportunity to get the car back is there in the chair's opinion. Once they're found innocent, if they're found guilty, we're still holding on to their car.
Well, so my understanding, and I do like line 347 down where, if it provides too hard of a hardship on the family beyond the state's benefit, then it can be transferred to another person in the family. So I appreciate that part. But my understanding with the way civil asset forfeiture works is they can take the property and hold it, or before there's even a conviction, they could sell the property or get rid of the property. And then that person, even if they're found innocent, would have no ability to get that property back to them.
Well,
So that's my concern.
yeah. Well, if I may, Mr. Chairman, the way I would address that is
Go ahead.
is number one, that this only kicks in if they've been found to be an habitual violator, as the chairman mentioned. And then secondly, I agree that those are, when it comes to civil asset forfeiture, those are conversations to have. I think we may want to, in another bill, in another conversation, address Chapter 16 of Title 9, which actually addresses civil asset forfeiture as a separate matter. And
I'm not going to hold up your bill because of this. I just want to state that, I do have concerns with, and I understand that they've been found guilty before, but what if they were falsely charged this time and it's their third time and they're not actually in violation? They're found innocent, but their property's taken away from them. And that's kind of a guilty until proven innocent instead of you have the right, the assumption of innocence until proven guilty. So I'm not going to hold your bill up for this. I would like to have some further discussion. And I agree, looking at that chapter in the code is something we need to look at.
understand. Thank you.
Number 16. Chairman Petrie, is that you?
Oh, I'm 16. I'm sorry. It says 23 here. I apologize, Chairman. Thank you. Thank you. And I just wanted to echo what the chairman said on this issue. I think this language is fine like it is. And what the sponsor, again, your comments about this is at a point where someone's a habitual violator. I mean, 3 violations with this kind of recklessness. This is a threat to society. And I'm not so concerned with the issue that was raised by Representative Clark. I think you need this language to send a clear message, and so I'm supportive of the language as it's written.
We have heard this bill twice in subcommittee, and at this time, the chair wanted to recognize Floor Leader Lott for a motion, but she has stepped out. So you had a question. What number are you? Go ahead.
Thank you, Mr. Chairman. My question is, who's going to enforce this? Are we going to have to create another police department to patrol the city of Atlanta to enforce this law?
No, appreciate the question. This was actually an issue that was brought to us by law enforcement to say that this was the tool that they needed in order to get to the root of this activity, which they believe is at that organizational level. So what we've provided now is an ability for law enforcement to go in and go after those that actually organize this activity. So I will tell you that all of the law enforcement that has testified before committee has made the commitment that once this is available to them, that they will pursue it to the best of their ability. So I think that once law enforcement has this ability, at that point, they'll be able to enforce it. I think a part of the challenge right now is that, to some degree with the activity that as it's taking place now, and they can only go after the participant, sometimes that's a little more difficult than if they can go after those that actually organize it. So I think that this will go a long way in giving law enforcement that tool they need to actually cut this off at the root.
Okay, well, thank you. I'd like to make a motion that we do pass them, Mr. Chairman.
We have a motion to do pass the committee substitute. House Bill 534. There's been a motion made and a second. Okay, at this time, all those in favor will say aye.
Aye.
All those opposed?
No.
Motion carries.
Thank you, Mr. Chairman. Thank you, committee.
Bills on the rules. Okay, we're going to move on to Representative Chokas's bill at this time. House Bill 631.
Thank you, Mr. Chairman and members of the committee. I respectfully bring before you today House Bill 631 by committee substitute. It's LC 392964S. The concept was brought to me by a deputy sheriff who has an autistic son, and basically what it does is it provides standards for our local E911 centers to collect information that they are given by the parents or guardian of autistic children or adults, so that when the E911 is called for an emergency and we have a first responder, fire, police, or someone approaching the home, that they know that there is an autistic child or an adult or someone else that has difficulties in that home. The responsibility is for the parent or guardian to give that information to the local E911, and that's the bill. The other thing on line 10, this is not will not go into law, but I'd like just to name this as Logan's List on behalf of the deputy sheriff that brought it to me. His son Logan is autistic, and with that said, I'll be happy to answer any questions.
Okay, thank you very much. Number 16 there. Is that Chairman Green? Oh, Chairman Petrie?
That's me. Thank you, Chairman. Just wanted to emphasize, thank you, Chairman Jokus, and wanted to mention that having served people with developmental disabilities for my entire life, this goes far beyond autism. Individuals with just a myriad of diagnoses that have an inability to communicate well, to understand, still can drive and function, and they go to work, but this can be very helpful to make sure that that we avoid any kind of unnecessary problems. And so much broader than autism, and thank you.
I appreciate you clarifying that. Thank you, sir.
Chairman Green, you have some comments for us?
Thank you, Mr. Chairman. The Euro Subcommittee had before it this morning this particular bill, and it was well received by the members of the committee, and they voted it unanimously out this morning. And we think it's something that we've needed for some time, and we just commend the author for this.
Okay.
Thank you, Mr. Chairman.
The appropriate time, Chair will entertain a motion.
Second.
Okay, motion has been made and seconded to pass House Bill 631, committee substitute. All those in favor?
Aye. Aye.
All those opposed? Okay, thank you very much.
Thank you, Mr. Chairman, members of the committee.
Let's go, let's move on now to House Bill 640, Representative Tyler Paul Smith from West Georgia's 18th House District will come forward.
Thank you, Mr. Chairman. I've got some more copies. I apologize. We're trying to get this sub for the committee.
Yes, 640, yes. 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 Yes, we are passing out a substitute to HB 640. LC 413077S. Is that what you have? Okay. Representative Smith, in your eloquent way, would you please present the bill to us here today?
Thank you, Mr. Chairman, members of the committee. It's good to see y'all again. Appreciate our subcommittee yesterday and the work that we did there. It looks like we got a little bit of work to do on this substitute that we brought before you. Just to kind of go over again what this bill does. Section 1, this places churches on the same footing as all other private property. It's up to the property owner to decide whether to allow weapons and use the criminal trespass laws to enforce a violation of that. Arguably, that section could be construed as a strict liability offense, but this is more so just placing our churches on the same footing as all other private property. Section 2, this requires probate court judges to accept Georgia weapons license applications. We've seen that many are still not, or are requiring several month wait times on account of COVID. Now, some of these wait times for the committees, just to jog y'all's memory, we have several months in between when they were last able to and their next available opportunity. In some instances, you have people that will have to wait until September of this year to be able to apply for a Georgia weapons license. And so this is an issue that this bill directly addresses. Also, you'll find in the bill that we have tried to meet our probate court judges' concerns. I know that they have a concern with the number of applicants coming in, whereas I'm sympathetic to them. We have tried to provide a solution to this issue that they've brought to us. And this would authorize the probate courts to go out and purchase a software program to allow them to accept online applications for new application for a carry permit or renewal permits. And you'll also see in section 2 what we have done upon, and if you want to read with me on this, starting on line 32, it'll state that upon notification of application of an applicant for a renewal of a weapons carry license or an applicant for a new weapons carry license, after 22 days of said notification of application, if there has been no notification of acceptance or denial of the applicant's application for a weapons carry license, the applicant who would otherwise be eligible for a weapons carry license shall be allowed to carry a weapon pursuant to this part until notified via first-class mail or email by the probate court of the denial of the applicant's application for a weapons carry license or renewal license. And just in case that raises your eyebrows, pay attention to the next words. An applicant who is not eligible for a weapons carry license as provided for under paragraph 2 of subsection B of this code section shall not be allowed to carry under the provisions of this code section. And so part 4 there, you'll see the words, the probate court shall be authorized to implement online application processes for weapons carry licenses and renewal licenses. Probate court shall also be authorized to accept a weapons carry license or renewal license application by first-class mail. So this is trying to alleviate the concerns of the probate courts that have an influx of these applications being, we're seeing a lot of people line up for weapons carry licenses right now, especially with events that we've seen occur. And so we want to be able to let the probate court judges better facilitate this. And I think this is a very good addition to this bill. One thing we did take out that I should have noted was in connection to another portion of it, we tried to look at local ordinances concerning different acreage amounts. We took that out. We've got to get back to the drawing board on that and kind of tighten that up as best we can. And so section 5 was an immunity provision, and that was connected to that section we'd already taken out. So that's why we took section 5 out of the previous sub. So if there are any questions, which I was about to skip over section 4. Section 4 of the bill, if you'll look with me. This is a cause of action or waive sovereign immunity for instances when the private right of action is created in case a probate court were not to be issuing or accepting these applications, as we've seen. This is a direct way for us to not only, we do have the writ of mandamus available to us to make sure that probate court judges do their job, but this also brings in a monetary fine that we can assess if we're successful in showing that a probate court judge has violated this new code section of not accepting these applications within the manner that they're supposed to. And I believe I'd spoken with Representative Lott, and I apologize for not getting this in the sub, but I do know this is a friendly amendment that she is going to offer whenever the appropriate time is, Mr. Chair.
Let me ask the author of the bill one question.
Okay.
Lines 18 and 19, if you'll direct your attention there.
Yes, sir.
On this sub, those lines are stricken. Was that supposed to be here?
Yes, sir, it was.
Okay. All right. Chairman Powell, if you would.
Thank you, Mr. Chairman. I want to thank the author of this bill. I want to thank the members who were here in the subcommittee yesterday as we hashed through this. You know, there's a number of issues that there hasn't been any cleanup language of the last since 2014, when a few of us moved this stuff forward to try to make it a workable relationship. And section 1 for the committee members, this has always been anxiety ridden since the day we did it, of trying to treat churches and religious property in some sort of a different fashion. Whether you might or may not agree, but some of the churches in this state have concerns about their safety. And because of the way it was previously written, those churches couldn't even appoint folks to have a weapon. Now, because of the concerns about the public safety, some of the churches were in fact having to violate the law behind the cloak of their board of deacons office to appoint somebody, which was normally their members who might be law enforcement trained or whatever, to have a weapon for the prevention of any type of activity that might be going on. So by doing this, this puts the churches on par with any other private property. If they don't want to allow weapons on their church, then they don't. They treat it as private property. If they want to appoint deacons or hire somebody to be with a weapon, concealed weapon, then they can do that. So it treats them like with the same private property rights that anyone else that have. On section 2, thanks to a little bit of work that went on since the discussion. And I want to thank the probate judge from Cobb County. I think she was very forthcoming. And some of the issues that we do know that there are some counties and some probate judges who do want to politicalize that process. Don't know who they are. I mean, we do know 1 or 2 of them that personally, they just don't like the idea of concealed weapons or Second Amendment rights, period. But as the kind probate judge said yesterday, that they're not there to make policy, and they're not there to make policy. The law is what it is. We've been very proud for years of our concealed weapon permit for the background checks, but you know, but in the reality of it, there's only one true benefit to that concealed weapon permit. That any Georgia citizen that goes and they apply, they have the background check done, they meet scrutiny of that. That little old plastic card has only one, well, actually 2 purposes. The most important one is that when they want to go purchase a weapon under the Federal Brady Act, they don't have to wait the 72 hours because they've already been background checked. They've already been scrutinized. The second would be reciprocity in some other states. South Carolina, my neighbors over there, it took us years to get reciprocity approved with them. Now it's that so they have some other credentials, but you know, it's not really there. But what this language does, thanks to the probate judge who told us the real angst in this COVID situation, and probably even further than that, is that they are just inundated by people, Georgia citizens, who want to have a concealed weapon permit. And they just can't get to them all. And I had made a reference back 6 years or so ago when we talked about all this. We looked at other possibilities. We looked at the possibility that the Georgia citizen in one county, maybe they should be able to go to another county to apply for their concealed weapon permit. And we looked at other things, but never did materialize. And the probate judges at that day, they wanted to retain that control in their county because this was bringing in revenue, quite frankly. And I remember that discussion at that time. But since then, what has happened is they're slammed. You know, she talked about a lot of different things, and it's not my interest in penalizing a probate judge or anybody else for trying to do their job. So what we've tried to do in this language, thanks to the author of the bill, that if you look on line 32, and what we've said in here is upon notification, which is if that citizen goes to the probate judge and they've submitted an application, if they can't get to it in that 22 days, this current law, that 22 days, then if that person is a law-abiding citizen and under all conditions, they would meet the same criteria of being able to legally carry their weapon, then they can do so. And upon the notification of that probate judge, that would basically consume it if they weren't eligible. And they would be, it's a variation. It's not constitutional carry by any means, but it's doing the right thing so that we don't have people who are held up from being able to carry a weapon, their concealed weapon privileges, because of the stalemate of the situation with this virus that's going on today. And that's the gist of it. And I want to thank the author. Other language in here does allow the probate judges to, or their counsel, if they so desire, to move forward. If they want to set up a database, a portal of some sort, and they can do it. Nothing would prohibit them to do it if they want to do it, to try to get this issue moving, because today, especially more so in today's society, Second Amendment positions are very ripe in people's minds, and they want to see it done right.
Thank you, Mr. Chair. Scott Holcomb online has a question to my seatmate. Are you with us?
I am. Thank you, Mr. Chairman. I want to ask the same question I asked the other day in terms of, can you define for me general damages on line 69? It's also another place in the bill, but it's on line 69.
Sure, and thank you, Representative Holcomb. I want to thank you in particular for pointing that out the other day. We want to make sure that we had the word general damages instead of actual damages. For actual damages, I mean, these would potentially be damages that are coming from a result of being denied this application or this weapons permit by their application not being accepted. It's not something that we want to just ascertain with a certain fine amount because it may be unique unto each individual that finds themselves as an aggrieved party that would be able to bring an action that this code section would allow for. So I wouldn't say that I would want to give one scenario as an example, because there could be a whole plethora of examples that are out there. So I'm not going to limit it just to that. I think each injury may be unique unto itself in these situations. One injury in, excuse me, Metro Atlanta may be different than a injury down in Chatham County. So to try to, prepare for every scenario or explain every scenario that this would cover, I think would be, it wouldn't be fair to the committee in trying to explain that, because as soon as I give you 5 explanations of a situation that actual damages would cover, you may have 5 more. So I'm not going to limit it just 1 or 5 or 10.
Without limiting it, can you give me just one so I can kind of understand it?
Well,
Amount of $100. The other part, I'm just not sure how that comes in.
Sure, generally. So, I mean, let's get into hypothetical here. For one violation in a county, you would probably see in a certain scenario, if you were, that application was just put to the side and nobody ever got to it. And you were trying to go and let's say that you were trying to purchase a weapon. And in a lot of our rural areas still, believe it or not, I break the news to you, there's still people that hunt to either supplement their food supply. And a lot of them, I know when I've hunted, I don't only carry whatever rifle or shotgun that I'm hunting with, I also carry a handgun with me. And a lot of times that'll be concealed. I will carry it concealed with my permit. And so that's a situation where, if I have some kind of, injury as a result of that, or, even being unable to go and purchase that firearm as an example in particular, you could look at that as being a damage that resulted from that. I will say this. If you have a situation where a judge has continuously acted in such a way that applications are not being processed, this gives you the opportunity where $100 may not have gotten the judge's attention. And you may very well have an injury that would be able to exceed $100 in that sort of scenario.
Okay, all right, we're moving right along. Number 6 there.
Yes, thank you.
Okay.
All righty, so you'll have to bear with me. I do have a few questions set. So I do need to understand, and make sure I understand 18 and 19. And I thank Chairman Powell also for making sure, going over that. But I need to know, what is it now for churches? What's the gun policy now?
So the policy now is arguably that it's a strict liability offense. You walk in, you don't know whether they allow for concealed carry or not. As soon as you go on the church ground, you're in violation of the law. And so this takes it from just a strict liability offense and the one where you have to know that you can't just violate the law by crossing over onto the property.
So they have to have a sign, they have policy and a sign say weapons are not allowed here.
I wouldn't submit that you had to have a sign for that, but I would say that there should be notice that this, and to point out, I mean, you still have a trespass action that you could provide for, and for violators, once they are told that you can't concealed carry here, that you would be able to tell that person that had come in with a concealed carry permit, hey, we don't allow that. If they refuse to leave, you could actually charge them with trespass for not leaving once they've been instructed to. So it still provides a remedy at law to make sure that if you don't want concealed carry in your church, then you can still have that right. And those that don't abide by that rule as the church has decided for their congregation, they can still enforce it.
And I have a question too. What about open carry? Can you open carry in any church, or is that the law right now?
I don't believe that it is. I know in other places in public that you can, but I know for my congregation, we actually, after the last gun bill that was passed, we actually enacted where you could both open and concealed carry in our church. So I would say that you still have that right to allow for concealed or open carry.
In current law?
In current law.
In a church? Yeah. Okay. All right, let's see. I wanted to,
Mr. Chairman.
yeah, I have another question, but I need to get my thoughts organized. So,
Sure.
Representative Gravely, you have a comment?
Yeah, just to, for the record, on the statement that was made earlier on church carry, the churches, I know in my district, there are churches that either put it out in their bulletin or they have a sign on the front of the church that prohibits the carrying of firearms on the church property and in the church facility. However, there are also other churches where the deacon board or the pastor or the church as an assembly has agreed that they would prefer open carry inside their church. So as long as the church is autonomous here and the church is allowed to make that decision. Thank you, Mr. Chairman.
Thank you. Got a follow-up question?
I do. I do have a comment, and I'm appreciative of this issue. I am aware of this issue also of, people waiting to get their permit. I've heard this also, but I would just like to remind us all that the whole reason we have the permit is, I understand about the rights of the gun owner, but the reason for that we have this system is to make sure that people that should not have access to guns don't get access to guns. People that, are for whatever reason, So I am very concerned about this bill, this legislation, and about the impact. And I'm concerned about if we allow them to get their permit, if it's after 20 days, they don't get their permit and they're eligible. Of course, as the judge said, they're going to think they're eligible, I mean, I'm eligible. And then they go get so they carry their weapon. I mean, they get the weapon and they carry it. But what if they're denied? What if they get the notice in the mail that they're denied? Then how do we know? How do we take it away? I mean, that's very problematic to me.
Adulting comes into play there at some point, I would think, ma'am. Number 7, is that Representative Crowe?
Yes. Thank you, Mr. Chairman. Just to Representative Evans' point about the permit being there for people to keep people from that aren't supposed to have guns from having guns. In my opinion, the permit, not having a permit only keeps law-abiding citizens from having guns. Generally, the criminals who aren't supposed to have them aren't going to abide by that anyway, whether they have a permit or not. So, but I did have one quick question on this, and what I want to make sure is I'm very in favor of the policy after 22 days if they've been delayed and they're eligible to have that. I think you and I talked about that earlier. But from a law enforcement standpoint, if an officer has an encounter with somebody who is carrying concealed now under this portion of the law, how can they or the officer be aware that they are operating under this portion of the law so that you don't have people being charged wrongfully or being punished because they are carrying under this, but there's no way for them to prove it. So that would be my only concern with it. I'm very much in favor of it, but I want to make sure there's a way for them to verify or for officers to verify that they are or are not carrying under this portion of the bill.
Sure. I think that would be with the officer of that jurisdiction to see that, they're to check with the probate court to see if that application has in fact been made. And it kind of goes back to this. It seems like more and more we have a stance in government that we too many times suspect our citizens of wrongdoing. The government is suspect of the citizens, quite like some of us citizens are suspect of our government a lot of times. It seems like that shoe has been on the other foot. And not to get into the theological weeds there, I would submit to you that officer would be able to call the probate court and check and see whether this application has been made. Now, if that denial letter has been sent and they're continuing to carry, then it would be just like it is now. And that's why we put in this provision starting in line 39 through line 41, that this would only apply to those applicants who are eligible under the code section.
Thank you. Number 16, Chairman Petrie.
Thank you, Chairman. And I asked this question, should be brief. I missed the subcommittee meeting because I had another committee. I just want to make sure that, so the 22 days piece, that is current law. So that's where that 22-day period is coming from. Is that correct?
No.
So what, tell me, to explain the rationale for the 22 days.
It come in part from our great probate court judge from Cobb County, about 22 days in processing these applications that they had received for carry permits and trying to get an issuance out to them. We're seeing that is that period is being far exceeded right now. Some because of backlog, some because they're just not taking applications. So this was a measuring point that we tried to give, even though we are giving them the ability in this bill to accept applications online, get a software program that will allow them to do that, and accept them by mail to help speed this up. If we still can't meet the point of getting this application in and reviewing it and getting a denial out within 22 days of this application, then we want to make sure that their concealed carry is still upheld by the state. We want to make sure that those who are eligible can still concealed carry and they're not penalized because the government can't process it. Because right now, as it stands, we're penalizing a citizen, not allowing them to have a concealed carry permit because the procedure is taking too long.
Okay.
So this
Right.
would
And
help
and
bridge.
if I can
that.
just say
Follow
one
up,
follow-up,
please.
Mr. Chairman, I just want to say, so I get that and I'm supportive of the measure. I just want to make sure that they understand the rationale for 22 days, that is the standard of promptness. And, obviously we want to make sure that we consider very fairly what that standard of promptness should be.
Right.
And so that was,
Yes, sir. Thank you,
4 liter
Mr.
lot. You have a comment or a question? Okay, Chairman Powell.
Well, I was going to answer Representative Evans. I was going to try to give my view to her observations, but my good friend Representative there had already beat me to it. But, I hear what you say, and I know that you certainly believe in the constitutional rights of folks, whether you agree with the Second Amendment or not. It is what it is. And, I can tell you that since this last legislation we passed some 6 years ago, I really don't know of a whole lot of instances where there have been problems with the concealed weapon permit of people violating the law. It might have been some minor discrepancies and such, but it's sort of like what was spoke of just a minute ago. I don't know many people who don't understand the basics of the law, that if you're a convicted felon, or if you were have been convicted of spousal abuse or domestic violence or something, they know that they're not eligible, especially those convicted of felony. Bad folks are going to have a weapon. Let me tell you something. If bad people want to have a weapon, they're going to have a weapon. They'll break into your home. They'll buy it on the street. They'll do whatever. The law-abiding folks are the ones that actually apply for a concealed weapons permit because they are law-abiding. And in this particular case, you have law-abiding citizens that are being penalized because of whatever the case. And I hate to use the term the drag time of bureaucracy, but it is what it is. And the applications are out there today that are just waiting and languishing, and the part that people just want to exercise their right. And these are law-abiding people. And this is for their sake.
Okay, thank you, Mr. Chairman. Representative Evans, we'll give you one more question, one more opportunity to make a remark, then we're going to call the question.
All right. On line 29, it says the renewal license shall be first come, first serve. So we heard from the probate judge president that they were doing appointments. Does this prohibit them from doing appointments?
So I think Representative Lott is going to have a amendment that helps clarify this situation. The problem we have seen with appointments, I'm just going to tell you, is there are people that can't get an appointment till September right now. We're in March, and they haven't been able to. And so this is a problem. It seems that we're moving almost heaven and earth in other courts to try to get things done, but we're not on this side of the court or this court. And so, I mean, we're still dealing with an effect on one of our constitutional rights. I mean, one of the original Bill of Rights. And so this is trying to meet that need, and not only placing a stress on them, but giving them a way to alleviate that stress. Because what I've heard is the majority of them, they're having a hard time facilitating a lot of the numbers. So, okay, we brought a solution to them. That is allowing them to do the online application process. I would hope, and I didn't want to outline a lot of procedures for them because our probate court, our courts in general are very innovative. We've all seen that, especially those of us that practice. And so I'm leaving it with the probate court judges as the best how to implement this. It would be good to see. I know if you go online, you can get certain probate court forms. It would incentivize our probate courts to provide this form online for people to apply for their carrier permit or renewal of their carrier permit. So that's part of this. And I think Representative Lott's amendment, whenever the appropriate time comes, will help clarify and give the probate courts a little bit more clarification on this.
Okay, 4-liter lot.
Yeah, thank you, Mr. Chairman. Thank you for bringing this bill as well, Representative Smith. So I do have an amendment, if now is the appropriate time to do that, Mr. Chairman?
Let's have a motion to approve the bill.
O77S.
Okay. Motion's been made and seconded to do pass. Now we'll entertain the amendment.
The amendment to remind the committee that was here on the previous hearing that we had, there was some question raised by the probate judge that attended, and she was clear to say that there was some flexibility throughout how they process 159 counties, that there's flexibility within their offices to do certain things. And it was brought up that the line 29 and 30, and actually really going into 30, where it says up to, that these can be processed up to no earlier than 30 minutes before the end of normal business hours. Not only did that line conflict with the way that she had been performing her duties, but it does in my county as well with my probate judge. So, and what I learned was she had stopped at 3:30. The probate judge that spoke with us, my county stops at 4 o'clock, which is 1 hour earlier. Hers was an hour and a half earlier. So what we decided, and I did have the opportunity to speak with the author about this, and I think that this is acceptable, certainly appears to be a better wording for me. On line 29, where it says renewal licenses on a first come, first served basis, after the word basis, I would like to add for a minimum of 7 hours daily, and then continue on with the sentence as is, during normal business hours, period. Strike and up to no earlier than 30 minutes before the end of normal business hours. The new language on line 29:30 would read renewal licenses on a first come, first served basis for a minimum of 7 hours daily during normal business hours. And that, in that case, our probate offices are open 8 to 5. It gives them actually 2 hours of flexibility within there, but they get to choose those options, and it gives them that freedom, but it also insists upon a time in which these can be processed.
Okay, you're making that in form of a motion?
Oh, yes, make a motion that those be the changes.
Okay. There's a motion made and seconded. Is everyone clear with the amendment that's been offered here? Everyone clear on that? Okay.
I am unclear. So that it has to be first come, first serve, not appointments, or are appointments still a possibility?
So I haven't affected, in my
The-
amendment, I have not affected the first
No.
come, first serve come.
We've not
Conversation.
affected that. So the motion's been made and seconded. All those in favor?
Aye.
All those opposed? Okay, the amendment passes. Okay, now we go back to the full bill as amended, House substitute to House Bill 640 as amended. All those in favor?
Aye.
Aye.
All those opposed?
No.
Okay, so there's 2 in objection there. Motion, the bill passes, and now we'll go to go on the rules.
Thank you, Mr. Chairman, members of the committee.
All right, the next bill on our agenda that we have here today will be Representative Crowe.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, this is House Bill 495, LC 412900. This is a department bill from the GBI. Hopefully will be a lot less controversial than the one we just had. It involves the Sexual Offender Registration Review Board, or SORB, as they're called. They conduct the sexual assessments or risk assessments of sexual offenders. And they originally employed investigators to gather, collect, and compile those documents to relative to each case. The investigators would gather documents from law enforcement agencies and other sources to be reviewed by SORB evaluators. In 2012, the investigator positions were transferred to the GBI. The GBI started conducting the records gathering duties for the SORB cases. Since that time, the investigative records gathering function has shifted back to SORB due to several factors. 2012, the existing 4 SORB investigator positions were transferred to the GBI. Upon transferring those positions to the GBI, they were classified as analyst positions, and the GBI added 1 additional position to the project. Over the course of several years, additional positions were added to support that function. Due to budget cuts in the fall of 2019, the GBI had to eliminate all but 2 of those positions, and this reduced the amount of work the GBI was able to provide for SORB. By that time, they had already begun doing some of the investigative records gathering functions themselves. And then during the 2020 legislative session, House Bill 720 was introduced. And if passed, it would have transferred one of those positions from the GBI to SORB, along with changing the nature of the GBI's responsibilities related to SORB. Unfortunately, House Bill 720 didn't pass during the 2020 legislative session. It made it out of the House and to the Senate, but I believe it ran out of time due to the shortened COVID session. But while it didn't pass, the fiscal year 21 state budget still reflected the transfer of funds for one of the GBI positions from the GBI budget and added funds to the SORB budget. And in July of 2020, SORB filled that investigator position, and SORB now conducts the investigative records gathering function for SORB cases. However, SORB is not able to directly obtain criminal history information, and SORB relies on the GBI to provide summarized criminal history information for SORB cases. So the 1 remaining position at GBI is utilized for filling these criminal history requests for SORB. That's what is currently happening, and this bill just brings the code in line with what is currently going on. And if you have any questions, I'll be glad to answer them.
Are there any questions for the author of the bill? Okay. Chair recognizes Floor Leader Lott,
I make a motion to pass.
seconded by Chairman Clark. Any further discussion? All those in favor, please signify by saying aye.
Aye.
All those opposed, like sign. I think the ayes clearly have that.
Thank you, sir.
Thank you.
committee.
Moving on to rules, we appreciate it. No further business before this committee here today. We will stand adjourned. Thank you all.